Welcome to The Explainer. In a courtroom, what's the one thing you think would prove you're telling the truth? Probably consistency, right? Well, get this. In court, you can't use it. We're diving into a really strange legal rule that says telling the same story twice doesn't actually make it true. It's a huge puzzle, so let's piece it together.
I mean, think about it. In your everyday life, if you tell your friends the same story more than once, they believe you. It's a sign of credibility. But in a courtroom, that logic gets totally flipped on its head. Trying to prove you've said something before can actually be forbidden. So why? Why does the legal system seem to distrust one of our most basic ways of figuring out who's being truthful?
So here's how we're going to break it all down. First, we'll tackle the main problem itself, the consistency puzzle. Then, we'll look at the loopholes, and there are a few big ones, like a huge exception for written statements. After that, we'll see why courts slam the door on things like lie detectors, and we'll wrap it all up by asking if this whole rule has become, well, a confusing fetish that might cause more problems than it solves. All right, Section 1, the consistency puzzle. Let's dig into the basic rule, which is really a rule against creating a narrative. It stops a witness from just building up their own story by repeating it over and over. Okay, so at its heart, the law basically says, just because you said it before doesn't make it true now. I mean, it makes sense, right? Someone who's planning to lie can just as easily repeat that lie multiple times. So the courts see it as self-serving, with very little, probative value, which is just a fancy way of saying it doesn't really help prove anything. The idea is to keep trials focused on hard evidence, not on who's the best at sticking to their script.
But you knew there was a but coming. Like pretty much every legal rule, there are exceptions. And that brings us right to Section 2 and the biggest loophole in this whole thing, the written statement exception.
And here it is, the main conflict in a nutshell. The general rule says your prior statement is a no-go. But then this major exception comes along and says, hold on, if it was a prior written statement in a civil case, well, that might be okay. That one little distinction, spoken versus written, can change absolutely everything. Now, there are some really important catches here. This exception is only for civil cases, not criminal ones, and you have to produce the original document. Now, this is crucial. The statement can be used as evidence of the facts in the statement, but it can't be used to legally corroborate or back up what the witness is saying on the stand. So the document really has to stand on its own 2 feet. And it's at its most powerful when it was written before anyone had a good reason to lie.
But here's the dangerous part. Legal experts are worried that this could be totally exploited. Just imagine a lawyer carefully writing out a witness statement, filling it with leading questions to get the perfect story. Then, that polished document gets submitted as evidence, maybe even replacing the raw, unpredictable back and forth of a live cross-examination. It could trigger what some have called an undesirable revolution in how trials are run.
Okay, so besides that big exception for written stuff, the common law has also created a few other, much more specific ways to get a prior statement in. So that brings us to Section 3, these other kind of niche loopholes. You've basically got 3 key situations. First, what someone says the moment they're accused of something. Second, what they say when they're found with incriminating stuff. And third, when a witness identifies a suspect out of a lineup. You see the common thread here. It's all about spontaneity. The law puts a lot of value on things said in the heat of the moment, before a person has had time to cook up a convincing lie.
Let's focus on that first one, because it's a real head-scratcher. In English law, the prosecution can sometimes introduce a statement where the accused actually denied the crime. Now, why would they do that? Well, the purpose isn't to prove they're innocent. It's to show the jury what their immediate reaction was. It's a way of showing, look, their story has been consistent from the very beginning. It's a very, very fine line to walk. And frankly, a lot of people think it's completely illogical.
Yeah, and this whole idea is super controversial. While it's a thing in England and has some legal backing in places like New South Wales, other courts have pretty much attacked it for not making sense. The feeling is that this particular exception is so confusing and strange that it probably won't survive for much longer. All right, let's switch gears a bit. What happens when modern technology tries to step in and just solve this whole truth problem for us? This brings us to Section 4, when science can't help. You've probably seen it in movies. Lie detectors, truth drugs. For decades, people have tried to bring this kind of tech into the courtroom, but the courts consistently say no. Why? Well, for one, it crashes right into the very rules we've just been talking about. But even more than that, judges just don't think these methods are scientifically reliable. They worry it would distort the trial and that juries would give the scientific results way, way too much weight ignoring other evidence. This quote from a New Zealand case really sums up the court's biggest fear perfectly. The judge said that allowing this kind of evidence wouldn't just be a new tool, it would move the system towards substituting trial by psychiatrist for trial by jury. The courts are essentially protecting the core idea that judging a person's credibility belongs to a jury of their peers, not a machine or a single expert. So, after all that, where does this leave us? Let's wrap this up in our final section, which asks a pretty provocative question. Is this rule just a confusing fetish? We're going to look at both its purpose and its problems. So, what's the verdict on this rule? Well, on the one hand, it does serve a purpose. It helps keep trials from going off the rails. But, in practice, it can become what one legal scholar called a confusing fetish. Just imagine you're on the witness stand and you keep getting cut off, unable to say something as simple and human as, "But that's what I told the officer right after it happened." The rule can completely stop a witness from telling their story in a natural way, leaving them confused and the jury without the full context.
And that really leaves us with this huge fundamental question. What's the main goal of a trial? Is it to be as legally efficient as possible, keeping everything neat and tidy according to a complex set of rules? Or is it to find the truth? Even if that means letting people tell their stories in the messy, repetitive, and sometimes roundabout way that human beings actually talk. There's definitely no easy answer.